This will be the first screenshot video for the crimes course, and it's going to be a rather short video because this posting uh, itself is short. Uh, so what we're looking at in this posting uh, is dispositions in criminal cases and classifications of offenses. And the first part, dispositions in criminal cases, would extend to the U.S. Legal system. Classification of offenses will focus us on the state of New York. What we can begin by observing is that in every criminal case, again in the U.S., I don't know how it is in Pakistan, by way of example, but in the U.S., there are four possible dispositions in a criminal case. Dispositions is sometimes known as an outcome. I use disposition because that's probably the vocabulary you will hear being used if you ever end up in some kind of a position where you're working as a lawyer or paralegal in the criminal justice system. So what we're saying is that if there's a criminal case, it's going to end in one of four ways. One way it can end is the defendant stands trial and is found guilty after trial. And I would suggest to you statistically that the majority of cases where a defendant stands trial will see the defendant being found guilty of at least some offense, maybe not all of the offenses that have been charged. Another way a defendant is found guilty is guilty by way of a plea. So that's our second outcome or disposition. And the process that leads to that is often referred to as plea bargaining. And one point I would make is that the criminal justice system in the US would collapse if there wasn't plea bargaining. Sometimes the law and order types say, well, we shouldn't have plea bargaining. Uh, Sometimes libertarians will tell you it's overused, that is plea bargaining, that people who are not guilty are forced into pleading guilty, and that may well be the case on occasion, which should trouble us. But what we can say is that there's not enough resources, courts, judges, prosecutors, defense attorneys, whereby every case can go to trial. And I think that then adds hydraulic pressures to many cases ending up with the defendant pleading guilty. Now, as I note, the idea of a plea bargain would likely see the defendant at least believing that he or she has got something or obtained something in return for the plea of guilty. Oftentimes, that is the ability to plead to an offense not as serious as the one the defendant was charged with. Sometimes that might include a sentencing commitment from the judge or an agreement on the prosecutor for more serious cases that the prosecutor will not seek a penalty greater than fill in the blank. But most of our criminal cases end up by way of this outcome. There is a possibility if a defendant does stand trial that the defendant would be found by a verdict of not guilty. Typically, defendants opt to have their case tried factually by a jury who will render the verdict, but it's on occasion we'll see a defendant waive his or her right to a jury trial and stand trial solely in front of a judge. Sometimes we call that, by the way, a bench trial. A fourth outcome is dismissal of the charges, and that is where the judge presiding over the case, uh, acting upon a request from the defense, uh, decides that the charge should be dismissed. At the end of the course, we'll look at various grounds for dismissal. For now, however, so we just don't let the topic hang, we could say that insufficiency of evidence could lead to a dismissal, possibly a denial of the right to a speedy trial. That doesn't happen nearly as much today as it used to, given the ability of prosecutors in large offices to keep better track of cases by way of technology. Another possibility, just to throw it out, is on occasion uh, a judge may dismiss a charge on the ground that the law under which the defendant has been charged is either unconstitutional generally or as applied to the defendant is unconstitutional. We used to see that happen a lot in so-called pornography, obscenity cases. The great American pornographer Larry Flynt, by way of example, was represented by a then Buffalo lawyer, Harold Price Maringer, and his protege, who is now a terrific criminal defense attorney in Buffalo, Paul Cambria. And they were often able to get the charges against Flynt dismissed because of that constitutionality ground. And more specifically, they would focus under the First Amendment. A movie you might want to consider watching, if you don't think you'll be offended, is People versus Larry Flynt. And Woody Harrelson does a great job in playing the late Larry Flynt. In any event, once that initial disposition is reached, it's possible that for 3 of the 4, we might see a different outcome, ultimately in the case because of the right to appeal. The only time we will not see an appeal ever is if the defendant has stood trial and has been found not guilty. The U.S. Constitution and the Fifth Amendment has a prohibition against double jeopardy. Person cannot be twice put in jeopardy. So the other 3 dispositions, however, can be appealed. Sometimes, oftentimes, actually, when the defendant pleads guilty, the defendant gives up the right to appeal. But even then, an appellate court can review the conviction if the court first finds that there might be a substantial injustice that's been done. But the only time there will be absolutely no right to appeal is if the defendant has been found not guilty. Now we're just going to move our focus a little bit into New York State, and this is going to be just a very basic distinction of classification of offenses, and that'll permit us to move through the New York State criminal court system, which will be the next posting in the next screenshot video. In New York State, there are 3 general classifications of offenses: felony, which is the most serious, and we can see that felonies are arranged from the most serious A felonies down to the least serious E felonies. Then a second general category is misdemeanor. A classic example of misdemeanor is shoplifting, unless it's from a jewelry store. And then thirdly, general category violation. A good example, I think, would be disorderly conduct. A violation, by the way, is an offense, not a crime, but it gets treated in the criminal justice system. So this classification of offenses gives us the information we need to go into the next posting and to the next screenshot video, which is a view of the New York State court system and how that system handles criminal cases. So this will conclude this video.